Lorber. I'm a mediator in California, and I have with me this morning Leslie Sultan. She is an estate planning attorney in New York. We met in the Divorce Network Professionals group, and Leslie had a really interesting PDF that I want to share with you today. And I thought it would be great for us to learn about what she is working on. So, Leslie, do you want to introduce yourself in this PDF?
Yeah, so thanks, Laura, for having me. We don't do divorces. We are strictly estate planning and estate planning related matters. And one of the things that we see a lot is that families, when they are going through a divorce or either before, during, or after, have a lot of questions about estate planning. And so we are limited as to what we can do with estate planning during a divorce. So we created sort of this checklist to help, people know what they can do, and of course what they absolutely should do once the divorce is finalized. So there's a lot of common mistakes that we see. For example, a married couple might own their house together. They might have a divorce settlement that says wife is getting the house and husband's walking away from it, but that does require a deed transfer, and a lot of times people either don't know that or they don't get around to it. And when somebody passes away later, the house is still in both of the names. So that obviously complicates things. So these are this is a checklist basically designed to help people figure out, it's very stressful going through a divorce. We understand how to sort of maneuver through that process on the estate planning side.
Excellent. Yeah. Like I said, I mostly mediate families and we're trying to figure out separation, but this is the things that I regularly didn't wasn't on my radar until I saw this great checklist. So I'm gonna stop sharing it now. And you and I just came up with some questions that we thought could help people to think through when they're getting ready, when they just are even just thinking about divorce.
Hmm.
And so, can you just paint a quick picture of what people should start thinking about when they're contemplating divorce before filing with the court? And some things that people often get wrong?
Sure, yeah. And also we can make the checklist available in the link so that people can
Yes.
download it. It is available online. We make it accessible to everyone, a simple website, download, done. And so before a divorce is filed, you actually have a lot more flexibility. So in states, I know New York, California, once you file for divorce, there's something called these automatic orders that go into effect. And that the orders are you can't change beneficiaries. You can't remove someone from life insurance or from a retirement fund. But before the divorce is filed, that automatic order is not yet in place. So if you're starting to think about divorcing, and sort of creating that separation, you can start changing those beneficiaries, right? If you've done it before the divorce, then you don't have to worry about it later. So, for example, if you have life insurance and your spouse, you can go ahead and change it now to a parent or a sibling. Just be very careful not naming minors as beneficiaries because minors cannot fill out a claim form. This is where estate planning comes in. If you wanted your children who are under 18 to receive it, then the best option would be creating a trust, which we can talk about later.
Yeah, very good. So, yeah, these automatic orders, they're designed so that when you first get divorced, everything kind of stabilizes and everybody has a moment to catch their breath and record a moment in time before we start deciding how to divide things up. But if you're not expecting them and you don't know to plan around them, it could hink, nobody knows what's going to happen in the course of divorce. And the last thing you want is for you to become incapacitated and now this person that you're trying to separate from takes um, something you didn't intend for them to have any longer. Well, thank you. That was a great answer. Um,
Yeah, and the
so
other thing on that, the topic of before the divorce. So if you haven't already done so, there's healthcare proxy, there's power of attorney, right? So these are actually documents that don't have to be, that are not subject to the automatic orders. So if you don't want your soon-to-be ex-spouse making healthcare decisions for you, you want to fill out a healthcare proxy. If you want to make sure something happens to you, you're alive, but you're in the hospital and you need someone to go and make bank withdrawals from your personal account, probably not the joint account, that's where power of attorney comes in. So those are forms that you can always change, but specifically if you haven't already done so, you want to do them before you file for divorce.
That makes a lot of sense. So it sounds like if you're even thinking about getting divorced and it's time for maybe that separation agreement, which I often help mediate before somebody even starts the divorce process, on your checklist before you file, you should be going and talking to somebody like you to just make sure that you know what's going to happen once you file and you're ready for it.
Mm-hmm.
Yeah. Um, so Um, I often help people create that separation agreement, as I just said, but I didn't really fully realize how much estate planning lives inside that separation agreement. What absolutely has to be addressed there, and what happens if it's not?
Yeah, so one of the things that most people don't realize is that you're still married even while you're in the divorce process. Even if you've signed sometimes that stipulation agreement, but you're waiting for the judge to fill out that final paperwork that says divorce decree ordered. So we've seen people die during that delayed process. And what does that mean under estate planning rules? It means your spouse inherits, even if you are in divorce. So the best thing that stipulation can have is something called a right. I'm sorry, a waiver of the right of election, meaning each spouse is entitled to an elective share, at least in New York and I believe California. I think there's some states that you can disinherit a spouse, but in a state like New York, you can't fully disinherit a spouse. They're entitled to an elective share. But that stipulation agreement can usually mutually waive that right. So I'm not going to come after your money. If you die, it'll go to your children or our children and vice versa. So one thing that I love to tell people in the mediation process is that stipulation is what, 30, 40, 50 pages long, right? There's a lot of details that can go into it. But if you guys can just agree to waive the spousal right of election, that can be one paragraph that you separate, sign independently while you're working out all those other details about the assets and the child support and all the other stuff.
Yeah,
Um,
100%.
but if you're at the point where everything's moving smoothly, you just want to make sure that stipulation has that waiver of the right of election or the right to inherit.
Yeah,
And
I think, sorry, go ahead.
no, and the same for retirement accounts. So a lot of retirement accounts, you have to have the spouse waive their right as the spouse in order to name somebody else. So you can't just go name your children or your sibling. So sometimes that can be done on the beneficiary side. They might still be entitled to a portion of the retirement, but the idea is when you die, if there's an inheritance there, it doesn't go to the spouse. It has to, and the spouse can waive that as well.
Yeah, you raised some really good points there. In California, the fastest you can get divorced is 6 months. And when you mediate a divorce, you're often finishing up that divorce in like 2 to 3 months. But you still have to wait the 6 months for it to be official. And so you're right. You can do stipulations in the meantime, and you would hate for all that hard work to just be thrown out because it doesn't have the judge's signature. So I think that's really important. Um, and every state has their rules about inheritance where it's just automatic. So you can't just leave it up in the air. If you're getting a divorce, you really need to think about what would happen in your state and what should happen based on your agreement. Um, so then we already touched on it when we're in court, but we have those automatic orders that get triggered in New York and California. So they're a little bit different in each, but what's the good news and the bad news about these restrictions?
I mean, obviously, the good news is your spouse isn't automatically removing you from, potential inheritance in beneficiary form, but obviously the restriction goes both ways. I also believe that you can waive this if both parties agree. So if both parties are saying, look, I've moved on, we've been living separately for a long time, we have grown children, we both agree that even though this divorce is still not finalized, we wanted the children to receive the benefit, not each other. And it's just less paperwork and less hassle if we can just agree to name them on these accounts. And so you can do another stipulation that says we acknowledge that this automatic order is in place, but we're agreeing that we can both do this. So that's something obviously you want to work with your mediator or divorce attorney just to make sure that that agreement will be acceptable to the court because you're modifying an order now from the court.
Right. So the good news is that if you didn't prepare ahead of time, you didn't know to do this, that you still can. But it's really important that if you are in court and you're trying to do it on your own, this would be a good time to just pay for an hour or two of an attorney's time or a mediator who also is an attorney to create a good order that would bypass the automatic orders or stipulations. Sorry, I said that wrong. Okay. So, you're in New York, so I'll just ask you to talk about New York law, but what what are the disinheritance rules around spouses in New York?
So if you don't have an estate plan, your spouse is entitled to 50,000 plus 50% if you're married and have children. If you're married with no children, it's 100% to the spouse. So assuming that there's children, the first 50,000 plus 50%, again, spouse. And if you have three children, they are dividing up the other 50%. So that's, if you have no plan in place. If you don't like that plan, you can do an estate plan, a will or a trust. Just the difference mostly being a will has to go through probate court. So now you're back in, your family's in court versus a trust, which lives outside the court, and we are big fans of. So you can disinherit your spouse in a will or a trust, technically, right? You can say, I don't want to leave anything to my spouse, but then that spouse has a right to an elective share, which is 1/3 or 50,000, whichever is greater. So in that case, sometimes people go ahead and they're like, I'll take my chances that I'm not going to die and I'll just get this over with now and I'm going to disinherit my spouse. And as long as they live past the divorce, then the spouse would not be entitled to anything. But if the grantor or the trust, the person writing the estate plan dies during the divorce, then the spouse will have the right to an elective share.
Yeah. You know what I'm really hearing in this whole conversation is, I love to mediate separation agreements. I think it's so important to know everything that you need to know before you start that file for divorce. Um, yes, you have 6 months to figure it out after you filed, but you also lose a lot of control. And so this really, I think, goes to this idea of, get on the same page, figure out how you're, in that separation, besides everything we're talking about, you can be figuring out, well, how do we want a divorce? Do we want to do it, with an attorney? Do we want to do it in mediation? Do we want to try to do everything ourselves, but we're going to talk to the attorneys and create the separation agreement that we can basically use before we go in? A lot of people don't understand that there's a lot that can happen outside of the court process and you have more control. You want to be in that court process because, of course, you could never actually be legally divorced without it, but also that's where your rights and your protections are. So it's good to know and be mindful that there's these different phases and different things we can do before and after court.
Yeah, 100%.
And then after court, post court, not just filing, but after you're divorced, what should be on your checklist now?
Oh, good question. Yeah. So as I mentioned in the beginning, if there's going to be a transfer of ownership of a house or bank accounts, do make sure to remove your spouse from those accounts legally and formally. And of course, post court, you're officially divorced. We know that that process is so traumatic and overwhelming. The last thing you want to think about probably is more legal stuff, but now you don't have a beneficiary on your accounts, right? So in some cases, the courts automatically will it'll say like the spouse is no longer can no longer act in a fiduciary capacity or can be removed as beneficiary. So now you don't have a beneficiary on your accounts. You have to now go and add someone. So we've seen where people forget to update their life insurance, their bank accounts. And so the beneficiary either remained the husband unless you can get a court order, the copy of the divorce order, or there's nobody. So now it's going under the laws of the state rather than what your wishes are. So, the checklist post divorce is, add beneficiaries to all your accounts, do a new healthcare proxy, do a new power of attorney. Again, if there's minor children, you want to maybe create a trust so that the trust can receive the money for the children and hold it until they're a certain age. This is my sweet spot. I know we haven't gotten to this yet, but trust planning for minors is so important. I went through an awful custody child support with my ex. We weren't married, so we were just dealing in that realm of child support and custody, but I did not, under any circumstance, want him to be in charge of my children's inheritance, right? But my children are minors. So by creating a trust, I was able to appoint my best friend. She will be able to manage the money for them. They might be living with him and he would be raising them, but any money that they're inheriting from me, he would not be able to touch. He can ask her to buy them things, pay for school, car, etc., but he's not going to manage it. And I feel very happy knowing that that's the case. So I'm a big fan of trust planning for parents of minor children, especially in sort of this divorce setup where you might not want your ex managing the money for a variety of reasons.
So, say somebody has that trust and heaven forbid you pass away and you have your best friend managing the trust for your kids. So, can your their father request child support from the trust or
So that's a good
enforce child
question.
support orders?
That's a good question. So I'm not aware that the child support has can be ordered from the court by the court from the trust. I don't believe so. Typically, what we see in divorce and child support proceedings is a requirement for there to be life insurance, and then purpose of that life insurance is if I die, the life insurance would pay him, and that payment would sort of be the amount of the child support had I lived until the children were 18, 21, whatever the rule is. And so it's sort of like this baseline amount of child support based on the quality of living. And so that's what that life support agreement,
Mhm.
child support agreement is with regards to life insurance in the settlement agreements. Um, so we don't have that. So there would be no obligation for my life insurance to go to him. And in some cases, I do believe that you can modify even the life insurance requirement in child support to make it so that the spouse is not getting the money and that the trust is getting it. So then they would be naming the trust again as receiving the benefit of the life insurance, paying the needs of the children, which include what we call the HEMS, Standard Health, Education, Maintenance, and Support, HEMS. And so then the trust would be paying for it automatically, anyways, because it's in the trust agreement. But we could always, work in conjunction with the estate planning attorney, the divorce attorney, or mediator to make sure that that language is there. So the father would give up the right to receive the benefit outright, but would make sure that the language is in the trust.
I can really, a lot of my clients aren't on the best terms with their ex, but when we're working together and don't really have high trust in them. So I can see this is a really nice way where you can trust that your kids are going to get the money that you're investing into that life insurance and it's not going to go into your ex's hands. It's really just going to be there for those kids, I think.
Right.
That's
And even
amazing,
if it goes to the ex, right, there's no guarantee that they're going to, we always worry, what are they going to spend the money on? How do we know they're using
right?
it for the kids? At least with the trust, there's a fiduciary obligation. It's a legal document.
Yeah.
What if the spouse receives it and then gets married and then gets divorced, right? Now the new spouse has a claim for whatever's in that bank account. So it's a much cleaner way actually to guarantee the child support and that the money goes to the children. It takes, this is sort of a paradigm shift in the
Yeah.
world of divorces, but we definitely try to educate people as much as possible about this option in hopes that they'll consider it.
This is really important stuff. I always say that divorce is a team sport. And, as your mediator, I'm just one of those pieces. You got to have you're consulting your attorney and your financial neutral and maybe a coach. But I hadn't thought that it's not just a divorce attorney you need on your team. You need an estate planning attorney, a probate attorney, as well. This is really great information. And the minute I saw your PDF, I thought, this is somebody who's thinking about things that I have never thought about. And just talking to you, I can just tell the depth that you really thought this through and you have a lot of experience on this. So, um, thank you for taking the time for talking to me today. And absolutely, I'll make sure when this gets posted to YouTube that you can grab that checklist straight from the comments there. So I really appreciate you taking the time and any last words?
No, I mean, I think you're doing a great service, Laura, getting this information out there and creating these conversations for people. And, I appreciate being invited. It was an honor. Thank you.
Oh, thank you. Well, have a great day. Thanks so
Thanks, you
much.
too.